Welcome to the New York City Bar Association program on ensuring accountability for political violence, lessons from January 6th. I'm Stephen Kass. I'm chair of our task force on the rule of law. I first want to send greetings and regrets from our newly elected president of the Bar Association, Susan Kohlmann, who had wanted very much to welcome you all as part of this program. She is unfortunately deep in the midst of a trial, and she's been unable to join us this evening. But she will be paying close attention, I know, to the recorded version of this program, which she regards as exceptionally important. Let me begin by quoting a phrase that we all know well. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. We all learned and were inspired by these words in school. We sometimes forget, though, what follows in our Declaration of Independence. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. In our democracy, in any democracy, the consent of the governed is determined in free and fair elections, not by mobs in the street or at the point of a gun. We are today witnessing the extraordinary price which one nation's citizens, the people of Ukraine, are willing to pay to protect their right to choose their own leaders. Yet on January 6, 2021, an incumbent American president who had been defeated in his bid for re-election encouraged thousands of his supporters to storm our Capitol in a coordinated effort to prevent Congress from certifying the results of that November election in which he had lost both the popular vote and in the Electoral College. That assault on our constitutional democracy failed, just barely, but it spawned a widespread effort by the defeated president's supporters to limit, call into question, and undermine the legitimacy of democratic elections in many of our states. This Bar Association has called on lawyers throughout the country to defend free and fair elections and the right of all eligible citizens to vote regardless of party or candidate preference. We have also called on lawyers to refuse to participate in frivolous or fraudulent lawsuits attacking the democratic process, the process that expresses and determines the consent of the government and is the foundation for the rule of law in our nation. As the great African-American civil rights leader, Ida B. Wells, said of an earlier era of our history, with no sacredness of the ballot, there can be no sacredness of human life itself. For if the strong can take the weak man's ballot when it suits his purpose, he will take his life also. If we are to defend democracy and the rule of law, we must hold those who planned and incited the January 6th assault accountable for their actions. For any failure to do so will continue to ripple through our land, as it already has. Tonight's program will seek to explore how our nation can best pursue that accountability when those who incited the assault may well include the former president of our country. While other nations, including Argentina, Chile, and Israel, have prosecuted and convicted former leaders for their actions, our nation has never really faced that prospect or had to consider whether pursuing a former president for alleged crimes in office would further divide our nation or instead help us reaffirm the fundamental democratic principle that no one, especially an elected leader, is above the law, and that the decision of the people in an election cannot be defied or overturned by those eager to acquire or retain power. We are fortunate to have with us tonight three thoughtful and distinguished speakers and an equally thoughtful and distinguished moderator to help us consider the wisest course for our nation in pursuing accountability for the political violence on January 6th and the implications of that violence for our democracy. I am therefore delighted to turn this program over to our moderator, retired New York State Appellate Division Justice Marcy Kahn, a member of our task force on the rule of law, who will introduce the speakers and explain the ground rules for tonight's program. I also wish to thank Judge Kahn and fellow task force member Jennifer Rogers for suggesting and organizing tonight's program, and welcome Judge Kahn both as our moderator this evening and, effective next month, as the incoming chair of our task force on the rule of law. Judge Kahn, the floor is yours.
Thank you very much, Steve, for your comments and for your remarkable service the past 3 years as task force chair. My thanks too to program chair Jennifer Rogers, who unfortunately was not able to be with us this evening. The unprecedented disruption of the peaceful transfer of governmental power, that is, the insurrection at the Capitol on January 6, 2021, interfering with our constitutional process of certifying the results of the presidential election, shocked the nation and resulted in multiple deaths and scores of injuries, including to the law enforcement personnel charged with protecting our government and its officials. So many of us thought that this could never occur in our country. Even more shocking, perhaps, were the actions of the former president and some public officials close to him, we are now learning, in inciting the events of that day, during the months leading up to January 6th and on that date. While prosecutions have been brought against hundreds of members of the mob which actually stormed the Capitol, very little has occurred to bring to justice those who incited, planned, funded, and enabled the insurrection to occur in order to set aside a free and fair election. Who will be held accountable for these actions? How can we assure that this will never happen again? While we await answers from all levels of government, tonight we explore the questions of how to assure accountability of those persons who were responsible for setting that horrible event in motion, even if that group includes the former president himself. Which branches of government can most effectively assure that accountability? And how can it be done while protecting democratic values and constitutional rights? How important is it that such action be taken? We are extremely fortunate indeed to have as our speakers this evening three thought leaders on these issues who will share their extraordinary scholarship, professional experience, and creative thinking with us. We will hear from former United States Attorney Barbara McQuade, Professor Gerard Maglioka, and civil rights attorney Joseph Sellers, each of whom will address what can and should be done from different perspectives on this topic. Preliminarily, our format for this evening's Zoom program will be that I will briefly introduce each speaker in turn, and after all three presentations have concluded, the speakers will take questions from me as moderator and from members of the audience. We have disabled the Zoom chat function, but you can type your questions into the Q&A function by clicking the tab at the bottom of your screen, and we will try to get to as many of them as time permits. All members of the audience will be muted and not on camera during the program. As I've said, our first speaker will be Barbara McQuade. She is professor of practice at the University of Michigan School of Law and was formerly the United States Attorney for the Eastern District of Michigan. While she was with the Justice Department, she worked on terrorism and national security issues for the Attorney General's Advisory Committee. Professor McQuaid is a legal analyst for NBC News and MSNBC, and frequently writes and speaks on issues related to the January 6th insurrection. Earlier this year, she published a model prosecution memo based on publicly available sources, analyzing potential federal criminal charges against former President Donald Trump for his efforts to set the 2020 election aside, including by pressuring Vice President Mike Pence to overturn the results of the Electoral College vote on January 6th. She will be addressing criminal liability of the former president and others for the events of January 6th. Professor McQuaid, the floor is yours.
Well, thank you so much, Judge Kahn. Thank you to Steve. And I also want to thank Jennifer Rogers for inviting me to join you all tonight. Wonderful to be with all of you. And thank you so much to the people who are joining to listen and learn. I know that there are many, many demands for your time in our world today. And it's so encouraging to me that people want to be aware of issues so that they can help. So thank you for joining. As you heard, I wrote a prosecution memo that appeared in Just Security in February. And that's what I'm going to talk about tonight. My guess is not all of you are criminal practitioners. Some of you are probably civil practitioners. And so I'm going to take you back to law school and thinking about criminal law a little bit for those of you who don't practice in that area. One of the things the Department of Justice does when it considers filing criminal charges is prosecutors prepare what is known as a prosecution memo. And it lays out for a supervisor and everybody up the chain of command the conclusions of an investigation. And so at the end of an investigation, a prosecutor will write this up. They'll lay out proposed charges that were considered to be filed, others that may have been considered and rejected. It will set out the evidence for each and every one of the elements of those offenses. It will anticipate defenses, and it'll make a recommendation. And that puts everybody on the same page to have a meaningful discussion about the evidence, the law, the recommendation, to make meaningful decisions. And so that's what I set out to do, is to draft a model prosecution memo. If I worked at the Justice Department and I had access to only the evidence that is currently in the public domain, could you make the case for charging Donald Trump and others for their roles in January 6th? And my conclusion is yes. And that's based solely on what is out there. Now, no doubt, actually investigating a case like this is much harder than just pretending to. I was able to look at information that had been gathered mostly by the January 6th committee, because a lot of the deposition testimony has entered the public domain. And of course, I don't have to think about whether I can really prove this case beyond a reasonable doubt to a jury of 12 people unanimously, people who may include people who are supporters of Donald Trump. And so really doing this takes far more time than I was able to do in February, because what prosecutors have to do is not only investigate the evidence, but also run down and disprove all the negatives. And that's what can take a lot of time. But if that can be done, and that's certainly information that's not in the public domain at the moment, then I lay out the case that Donald Trump can be charged under two statutes. The first is conspiracy to defraud the United States, sometimes referred to as a Klein conspiracy. And the other is obstruction of an official proceeding. That's a charge that has been used against a number of the people who joined in on the January 6th attack. And so when a prosecutor goes through this analysis, they answer two big questions. One is, can these crimes be charged? It's a legal question. Is there sufficient evidence such that it is probable that a conviction can be obtained and sustained on appeal? That's the legal question. And then there is also a discretionary question. That's not just can we charge this case, but should we charge this case? And that's where prosecutorial discretion comes in, thinking about things like fairness and scarce resources, and whether there's a substantial federal interest or an adequate alternative to criminal prosecution. So just because you can charge a crime doesn't mean you should. And so I'm going to talk about both of those prongs as I did in my memo. And that's what typically gets included in these memos. All right, so first, I'm going to talk about these two proposed crimes: conspiracy to defraud the United States and obstruction of an official proceeding. Now, for those of you who do not practice criminal law, I'm going to take you back to first-year criminal law class, or maybe your bar review course where you thought about things like elements of offenses. I know lots of civil laws use elements as well, but those are the building blocks of crimes, elements of offenses. And so what are the elements of these various crimes? So first, conspiracy to defraud the United States. This is sometimes referred to as a Klein conspiracy because it comes from a case of that name. And it essentially means that people agreed to work together to obstruct or interfere with some sort of function of government. And in this case, the theory would be that Donald Trump and others conspired to interfere with the fair administration of elections and the peaceful transfer of power. So the elements of conspiracy to defraud the United States are that the defendant entered into an agreement with others. And so you'd have to charge Donald Trump not alone, but with others. And I would submit that John Eastman, one of the lawyers he was consulting with, or Rudy Giuliani, and or Mark Meadows, who was present for most of these meetings, would be potential co-conspirators. That agreement had to be to obstruct a lawful function of government, in this case, the peaceful transfer of power through the election apparatus, by fraud, by deceitful or dishonest means. And that one's the trickiest one. And that one of the parties committed at least one overt act in furtherance of the conspiracy. That one's pretty easy. If you can show a text or a phone message or a meeting or a tweet, that would be sufficient. It doesn't take much, and it need not be any illegal act. It can just be any sort of act. So those are the elements. And then I'll also talk about the other crime, which is obstruction of an official proceeding. And the elements are really pretty similar. They're a little bit different. They require that the defendant obstructed or impeded or attempted to obstruct or impede an official proceeding of the United States. And so far, we've had something like 20 judges determine that the certification of the vote on January 6th was, in fact, an official proceeding, and that the defendant did so corruptly. So it goes back to that same idea of whether there was dishonest means there. And you may also remember from your time in law school or studying for the bar exam that all of these crimes really can get reduced to some very simple elements. Actus Reyes, what they did, and mens rea, having the necessary criminal intent. Sometimes there are also these things called attendant circumstances. I think in these cases, those elements here are pretty easily met. I think the actus reus here is also fairly easily met. The harder ones, I think, will be proving that fraudulent intent by Donald Trump and his co-conspirators. So let's talk about actus reus first. For both of these crimes, they're really fairly similar. You have to show that Trump and others did something to try to obstruct this official proceeding, or they did something to try to interfere with the certification process. And so what are those things? Well, one, in the public domain, there are many, many public examples of Donald Trump trying to pressure Vice President Mike Pence to refuse to certify the election results on January 6th. He did it in meetings that there is testimony about. He did it at the January 6th rally on the Ellipse, where he demanded that he do it. And he tweeted about it, where he said, Mike Pence needs to do the right thing. So the fact of this actus reus is pretty strong, that he pressured Mike Pence. One thing I want to mention is there's an awful lot of attention being paid to whether Donald Trump incited the mob to go attack the Capitol. Maybe he did and maybe he didn't. Maybe he was reckless and he hoped that would happen, but he didn't know. Maybe he conspired with those people. I don't know. But one point I want to make is it is not necessary to prove that he in any way set that mob down to interfere at the Capitol. And so I think it's become a bit of a distraction. Now, if you can prove it, that's pretty explosive. And so maybe that's worth looking at. We've seen some of these oath keepers who've pled guilty to seditious conspiracy, 3 of them now, agree to cooperate against others. And we know that one of them was with Roger Stone on January 5th and 6th at the Willer Hotel. So you may be able to prove that case. But even if you can't, that's not an impediment, because I think the actus reus is sufficient, just showing that Donald Trump pressured Mike Pence to abuse his authority and stop the certification. So I think you've got plenty of actus reus there. I think you can also show actus reus by what Donald Trump tried to do with the Justice Department. Remember, it includes attempt. He pushed the Justice Department to make public statements that there were irregularities and fraud. And when they pushed back again and again and said, no, there's nothing here, he said, well, just say you're investigating fraud and leave the rest to me and Republican members of Congress. And so that's part of the effort to the Actus Reyes here of the crime of interfering with an official proceeding or defrauding the United States. And then I think a third Actus Reyes is his efforts that we have recorded of his phone call with Georgia Secretary of State Brad Raffensperger, where he asked him to find 11,780 votes, which would be enough to defeat Joe Biden's margin of victory. I think all of those things can constitute Actus Reyes. Any one of them alone is enough. I think all three of them are provable. And then I think that fourth, the inciting the mob or agreeing with the mob, is a possibility. I want to see just one other word about that DOJ pressure as well. I think that this one is really, really important, and it is one that has not gotten as much attention as I believe it deserves. If you look at the testimony that has already been given by Jeffrey Rosen, who was the acting attorney general at the time, and Richard Donahue, who was his deputy, they have testified that there was this DOJ official named Jeffrey Clark who drafted a letter that he wanted DOJ officials to send to Georgia and other swing states, telling them that their legislatures could convene and select their alternate slate of electors, their own, that DOJ was investigating irregularities, and that perhaps they might want to do this. This is so out of bounds for anything DOJ would do. Number one, it was based on a lie that DOJ had found election irregularities. But two, suggesting to state legislatures that they should throw out the votes of the voters and substitute their own view. These are Republican-controlled legislatures in states where Joe Biden had won the popular vote and the electoral votes. That is breathtaking. And he met, in contrary to DOJ policy, privately with Donald Trump to talk about how they could advance this scheme. And he pushed Jeffrey Rosen and Richard Donahue to push on this scheme. And when they refused, he told them that Donald Trump was going to fire them and replace him with Jeffrey Clark. In response, Rosen and Donahue demanded a meeting at the Oval Office. And before that meeting occurred, this is on January 3rd of 2021, before that meeting occurred, it's on a Sunday night, it was scheduled for 6 p.m. They drafted an email, Richard Donahue did, to send out to DOJ leadership, all of the component heads, and the chairs of the Attorney General's Advisory Committee, which is the leadership of all 93 US attorneys. And what they said is they were ready to hit send after this meeting. And what they said is during this meeting, President Trump fired Jeffrey Rosen as the acting attorney general, installed Jeffrey Clark for the purpose of defrauding the union out of the election. We are all resigning. And whether you do or not is up to you, but you really ought to think about what you want to do in good conscience. Imagine if that had gone out. Now, when this meeting occurred, Rosen and Donahue pushed back. They threatened to resign. Even White House counsel Pat Cipollone and Patrick Philbin also threatened to resign. And they told Trump what would happen if he persisted in this path. And so he backed down. And so they didn't hit send. But can you imagine for just a moment what would have happened if he had persisted? We would have had something far, far greater than the Saturday Night Massacre. We would have had the resignation of probably more than 100 officials from the Department of Justice, with all 93 US attorneys, plus all of the component heads at DOJ, plus the White House counsel's office. Now, does that exonerate Trump because he backed down? No, he didn't change the big picture. He just pivoted to a new plan. All right, DOJ is not going to play ball. Fine, I'll just go in a different direction. I'll pressure Mike Pence to do my bidding since I can't get anything done at DOJ. And I'll call Brad Raffensperger in Georgia and try to get it done that way. So that's the Actus Reyes part. There is plenty of Actus Reyes without worrying about what happened with the mob. All right, so let's talk about the harder element now, and that's the mens rea. This is the knowledge that the election was not in fact stolen, which is required to prove that Donald Trump acted with fraudulent intent. How do you prove that? Much harder. And it has to be proved by an inference. Juries will be instructed in a criminal case that because you cannot read a person's mind, you must draw reasonable inferences, drawing on your common sense based on what the person said and did and the totality of the circumstances. So what is that totality of the circumstances? Well, we still don't know all of it because of course the investigation continues, but just what is in the public domain includes this. Shortly after the election, Donald Trump's own chief of cybersecurity for the Department of Homeland Security, Christopher Krebs, issued a public statement that said there was no fraud in the election, that there was no cyber interference whatsoever. He got fired for doing that. We know that William Barr made a public statement that there was no fraud at the scope possible to turn the outcome of the election. When he pushed on that in December, and he said to Donald Trump, if you don't want to go along with it, I'll submit my resignation. And Trump said, accepted. So Barr lost his job over this as well. His own DOJ Attorney General. Trump's own campaign wrote a memo in November that said, you know, we've investigated all the stuff about these Dominion voting machines and whether they could have flipped for Biden. And we've concluded that none of that is true. Trump knew that. On election night itself, when the returns were coming in, as everyone expected them, as Donald Trump himself predicted before the election, all of the mail-in voting, which got counted later, started flipping elections for Joe Biden. In the early returns, when they counted the live in-person votes, many swing states showed Trump ahead. When they started counting the vote by mail and the early voting, no surprise, those votes went for Biden. And so when those numbers started changing the way Trump didn't like, Giuliani said to him, just say we won. Just say we won. And that's what he did. They just started saying they won. In addition to those things I've mentioned, the Director of National Intelligence, also handpicked by Donald Trump, John Ratcliffe, said there was no intelligence information indicating any election interference. We know about the call with Brad Raffensperger, who told Trump there was no fraud in Georgia, and yet he persisted. And then 60 judges around the country in lawsuits filed by Giuliani and Sidney Powell and others challenging the outcome in various states, all of them said there was no fraud. There was one judge that ruled in favor of Trump on one of these challenges, but it didn't have to do with changing the outcome. It just had to do with a procedural change regarding affidavits. It would not have changed the outcome. And so after a while, you think there's all of this overwhelming evidence of no fraud. What is the evidence that there is fraud? Well, as a judge wrote in suspending the law license of Rudy Giuliani, there is not one scintilla of evidence that there is fraud. There's a jury instruction that jurors get in proving intent that talks about willful blindness. And what it says is a defendant cannot ignore a high probability that a fact is true just by turning a blind eye to it. That's what Donald Trump has done here. Whether he's ever admitted it out loud or even to himself, he is turning a blind eye to the facts, and you can't do that. And so I would argue that any rational juror would find that there is evidence of fraud here. So you can prove the Actus Reyes and you can prove the mens rea. So that's the can we charge part, the legal part. The harder question in this case might be the discretionary part, the should we charge part. Should we charge a case even if we can prove it? Well, first, is there a substantial federal interest? Wow, I mean, think about that. Could someone get away with trying to cheat on the election, try to steal an election, try to thwart the peaceful transfer of power? That seems like a pretty substantial federal interest that needs to be deterred, punished, and held accountable. And it's not just to look back and hold accountable people who've committed crimes in the past, but also to deter others who might try to do it in the future. There's certainly been rumblings that there may be efforts underway to try to do this again in 2024. And so to stop that, you have to hold accountable the people who tried before. Are there adequate alternatives to criminal prosecution here? Well, we've got perhaps civil lawsuits. We're going to hear about that in a minute. Certainly civil lawsuits could be an interesting way to address this. You only have to prove the case by a preponderance of the evidence, not beyond a reasonable doubt. And so that could be an interesting way to stop things. But would it really hold someone accountable? You know, civil cases can only bring injunctive relief or money damages. You can't punish people criminally, which brings with it all of the moral reprobation that comes with it. So I don't think that's adequate. How about the January 6th committee that is investigating this? Well, that's important and they're doing important work, and that can have a political consequence, or it can even help change laws to help prevent this from happening in the first place, but it can't really hold people accountable for what they've done. How about the state prosecution in Georgia? We know that in Georgia, a prosecutor is investigating the alleged efforts to engage in fraud there. That's not bad, but it's not the right scale. It's only Georgia, not all of these other states where we saw this effort to be done in a number of different states and on a national scale. And so I come down to the conclusion that there is not any adequate alternative remedy to criminal prosecution. It does advance a substantial federal interest. And the last question is, but what's the cost? What if Donald Trump is prosecuted? Would that bring with it civil unrest or civil war? And what if he's charged and acquitted? That could be even worse. When you think about all the negative consequences, I think they're very real. And I think a very sober assessment needs to be made as to whether they would create so many negative consequences that someone ought to really think carefully and hard about whether to bring charges. And I think those possible consequences are very, very bad. But I think there's only one thing worse, and that is leaving these crimes unaddressed. I come down that on the side of the only way to make sure this never happens again is to hold those who committed it criminally responsible. I'll end there and look forward to taking your questions after the conclusion of the other speakers.
Thank you very much, Professor McQuaid. We will all wait and see what, if any, action is taken by the Justice Department, which has now made a request for transcripts of interviews from the 1-6 committee, and we'll see if there is a prosecution, how closely it follows your prosecution memo. And I do commend the reading of Professor McQuaid's prosecution memo to everyone. It's in Just Security, and she has put the link in the chat, but I think you can't see the chat. So we'll get that posted on the Bar Association website, and you can see it. Our next speaker is Gerard Maglioka. He is the Samuel R. Rosen Professor of Law at the Indiana University Robert H. McKinney School of Law. He writes extensively on constitutional law and is widely regarded as the nation's preeminent commentator on Section 3 of the 14th Amendment, otherwise known as the Disqualification Clause. He has often been sought for his views on the potential constitutional disqualification from seeking or holding public office of participants in the events leading up to and occurring on January 6th, which has turned out not to be merely an academic exercise given the field of candidates this year. Professor Maglioka has been engaged as an expert witness in the proceedings brought by voters under the 14th Amendment, Section 3, to challenge candidates based on their alleged support of the insurrection. And he testified recently in the proceedings in Georgia involving Representative Marjorie Taylor Greene. We are thrilled tonight to be among the first to hear from him after his detailed analysis was adopted in yesterday's decision by the Fourth Circuit Court of Appeals in the Madison Cawthorn case. He will discuss that ruling along with the application more generally of Section 3 to public officials who were involved in promoting the January 6th attempted coup. Professor Maglioka, the floor is yours.
Well, thank you, Judge Kahn. Thank you to everyone at the New York City Bar Association for hosting this panel and for inviting me. I'm delighted to be here. Let me just begin by summarizing Section 3 of the 14th Amendment for those of you who are not familiar with that provision. Section 3 was, of course, ratified after the Civil War and essentially was designed to bar former Confederate officials, both civil and military, from serving in office again unless they received amnesty from a vote of a supermajority of Congress. Now, in 2020, I decided to write a law review article about Section 3, largely because I thought to myself, is there any part of the Constitution that no one's ever written about? And the only one I could really come up with was Section 3 of the 14th Amendment. So I researched and wrote that article. It was quite interesting. I posted the paper in December of 2020 for other, well, probably a small number of interested scholars to look at. And then a few weeks later, January 6th happens. And that night, when members of Congress began to describe what had occurred as an insurrection, the thought naturally ran through my head that this would not then just be a historical piece, that there could be contemporary application. It was the furthest thing from my mind when I wrote the article, but there we are. Okay, so what are the difficulties involved in applying Section 3 of the 14th Amendment now? And there are many. So let me just run through 3 of them. First, essentially this provision has not been enforced for 150 years. So therefore, there's not much in any recent time to draw upon. And of course, the sort of legal and political circumstances have changed considerably since the provision was ratified in 1868. That's one problem. A second problem is that the provision was only enforced for about 4 or 5 years after ratification, during a kind of the high tide, you might say, of Reconstruction. And thus, there were not many cases, not many authorities created that give us a lot of guidance about what to do now with that provision. So not only was the enforcement a long time ago, but it also wasn't all that much of it, especially as compared to other constitutional provisions. Third, when Section 3 was debated in Congress and then ratified, everyone understood that being a part of the Confederacy meant that you were engaged in insurrection against the Constitution of the United States and were therefore going to be barred from service unless Congress gave amnesty. So there was not a lot of consideration given to what is an insurrection, what does it mean to be engaged in insurrection. I mean, there was a little bit here and there, but certainly not as much as we would like to see now that we are looking back for guidance for the present circumstances. So one possible solution to all of these problems would be for Congress now to enact a general enforcement statute for Section 3. There was an enforcement statute that was enacted in 1870 that applied Section 3 to office holders and explained sort of the process that you would go through, basically involving United States attorneys bringing actions, civil actions, to enforce Section 3 against existing office holders. But that provision was repealed in the 1940s. It's not exactly clear why, although apparently people just thought it was obsolete and there was no need for it anymore, so they just took it out. All we have on the books now from the federal side of things is the federal criminal insurrection statute, which, as far as I can tell, has never actually been used, which has with it a long prison sentence as well as disqualification from service in office. We'd be better off if there were a general federal law enacted. There was a bill introduced last year to do something like that, but it went nowhere and it probably has no prospects of going anywhere anytime soon. So what are we left with instead? Basically a state-by-state process to enforce Section 3, which means that everyone involved, whether they are challenging candidates or office holders, or whether they are defending candidates or office holders from those challenges, are really kind of groping in the dark, going through a lot of trial and error to figure out what's going on, because they have little authority to work with. There is a lot of inconsistency from state to state about who can bring a challenge, can anyone bring a challenge, what's the standard of proof if you bring a challenge, and so on. It's really, in a sense, a kind of common law process in real time. That is, you have lots of challenges in different jurisdictions with different fora for those challenges, and each one involving different people and different facts, although all broadly speaking related to the January 6th violence. And there's a feedback that you're getting from one case to the next as to whether certain arguments seem to work or seem not to work, or how are these things being framed. So that's beginning to generate some resources that people can use for the challenges to come. But still, we have a long way to go to get any clarity on the parameters of Section 3 as applied to what occurred in January 6, 2021. Let me just run through briefly kind of the cases that have either been decided in the states or that are pending, just because I can give you a kind of comprehensive survey of those cases, given that there is a pretty small universe of them. So there were challenges filed in Arizona against 2 members of Congress, as well as a state legislator who is running for Secretary of State of Arizona. Those challenges were dismissed by the Arizona Supreme Court in a fairly brief order, which simply said that they didn't think that state law permitted such a challenge under the state election statute. And of course, it's worth pointing out that all of the state election statutes were not written with Section 3 of the 14th Amendment in mind, because nobody really gave it much thought until about a year and a half ago. And also, there were no state election statutes basically in 1868 when Section 3 of the 14th Amendment was ratified. So there isn't really much one can look back to help think through that problem. But so those challenges have been dismissed. In Georgia, as Judge Kahn mentioned, there was a challenge to Congresswoman Taylor Greene, where a state administrative proceeding had testimony or took testimony from her about her role in the January 6th violence, and concluded on the merits that she did not engage in insurrection under the Constitution, that there was insufficient evidence to establish that point. Now, that case is on appeal. She won her primary yesterday, so it's not entirely clear what will happen to the appeal. It's possible that the challenge will just be converted on appeal into a general election challenge to her eligibility to run. But that's sort of the status of that. In North Carolina, there was a challenge to Congressman Madison Cawthorn. And of course, he lost his primary last week. But nevertheless, yesterday, as Judge Kahn mentioned, the Fourth Circuit ruled in a case basically where he had sought to block the state of North Carolina from holding an inquiry into his eligibility to be in the primary. And the Fourth Circuit held that essentially, or reversed the district court's judgment in that case, granting an injunction against the state eligibility hearing. And I'll talk a little bit more in a moment about what the Fourth Circuit said, though as a practical matter, since Cawthorn lost primary, at least for now, there will be no further proceedings other than to dismiss the case as moot once their election is certified. There is a pending lawsuit in Wisconsin against Senator Ron Johnson and 2 members of the House in federal court. That one, I don't know that the court will reach the merits in that case, but we will see. And there's also a proceeding pending in New Mexico against a county commissioner who is an actual official rather than a candidate. So the challenge is essentially saying that he must be removed from office because of his role in the January 6th insurrection, not that he cannot run again for office. That challenge is still in a fairly early stage, but might be the most significant one for this year. Really, the kind of question in all of these cases, besides whatever law is generated that can provide guidance for future challenges, is will anyone actually be either disqualified or ousted from office? Because if one person is disqualified or ousted, that creates the precedent that can be used against Donald Trump should he run again for president. Because in effect, what we know about almost all of these people against whom these challenges have been brought is that they were more marginal or peripheral to the events of January 6th than Donald Trump was. So it seems like if any one of these peripheral or marginal figures is disqualified or ousted because there is a determination that the January 6th attack was an insurrection and that they had engaged in insurrection, then it would seem like a fortiori Donald Trump would also be disqualified or ousted because his role in those events was far, far greater. Now, will anyone be disqualified or ousted? I cannot say, though I would point out that the challenges that are pending to state officials, such as the gentleman in New Mexico that I mentioned, or potentially other challenges that may be brought, have a somewhat greater prospect for success than challenges being brought to federal officials. You know, members of Congress can raise defenses on the merits that, say, a state executive official or local official cannot, just by virtue of their sort of position and the unique kind of role that Congress plays in judging the qualifications of its own members. So I would think that if anyone is disqualified or ousted, it would be a state or local official where the precedent would be created in a state where a state court concludes that state law, you know, contemplates a Section 3 challenge. Now, you know, another thing to point out is that in some instances, it may be impossible to challenge a candidate on Section 3 grounds, but you can challenge an office holder on the same grounds, right? That is, you might say, well, look, the challenge can only happen once the person's in office, where you are then going to say that they are, in essence, an imposter or illegally holding the office that they've been elected to. Now, I would submit that it's far better if we decide whether people can serve in office before they are elected rather than after, because it creates more problems for everyone if an office holder is found to be an imposter when they're in office. But state law may leave little choice on these matters. You know, to take an example, the Republican nominee for governor in Pennsylvania, Mr. Mastriano, has had allegations made against him regarding his involvement in January 6th. It's not clear, though, that Pennsylvania law contemplates a challenge to a candidate, at least at this stage, post-primary. But, well, if he were to win, then someone would bring a challenge against him and saying he can't be the governor, that he's an imposter governor. That's not a great situation for the people of Pennsylvania to find themselves in. They may not, of course, be in that situation. He may not win. But it goes to show that in this cycle, we have challenges mostly against candidates, but the next cycle might be challenges against office holders if you weren't able to bring the challenge against the person as a candidate. Okay, now, this all then builds up to the question of what about Donald Trump? Because while holding accountable various individuals, whether they be members of Congress or state or local officials or former military officers who may have been involved in January 6th, is important, right? I think it's all focused, or most of the attention is drawn to the fact of, well, can former President Trump actually run and serve again as president, right? That's what this is all sort of leading to. And indeed, next year, you can expect challenges to be brought all across the country should Donald Trump decide to run again. The first thing to say about those challenges is that the Supreme Court is going to have to decide the matter. And the sooner they decide, the better. Because basically, there is no way in which you're going to get a consensus among the states as to whether Donald Trump is eligible to run for president or not. I mean, in our politically polarized time, that's not possible. And moreover, it's just hard to imagine you're going to get similar views out of all of the states on that very difficult question. So the Supreme Court's going to have to decide. And they need to decide because we have to know as soon as possible whether, in fact, he can run. I mean, we can't have a prolonged period of uncertainty, whether in the Republican nominating process or in a general election, about whether one major candidate is in fact an eligible candidate or not. So I would certainly hope and I expect prompt Supreme Court review whenever one of these cases involving a challenge gets anywhere near them. Now, much as they probably don't want to decide this, because they have enough problems as it is, they're going to have no choice, and we need to know. Okay, now what are some of the issues that are going to come up when a challenge is made to Donald Trump? I'll just run through a couple of leading ones. I mean, you can think of some of them yourself, I'm sure, in terms of, well, do you think that what occurred on January 6th was an insurrection in the constitutional sense of that term? Do you think that Donald Trump engaged in insurrection, given whatever evidence there is by that point about his involvement? Okay, but let's throw out a couple of others. One argument that has been made is that when Congress gave amnesty to most of the former Confederates who were covered by Section 3, which was done in 1872, that they also gave amnesty to any and all future insurrectionists because they were being very generous, I guess, under this theory. This is a kind of, well, preposterous argument that was rejected by the Fourth Circuit in yesterday's opinion in the Cawthorn case. It's preposterous because no one at the time even remotely thought that's what they were doing. They were focused entirely on dealing with the people in front of them who were covered by Section 3, not people, you know, in the future. And as the opinion yesterday put it very nicely, Jefferson Davis was excluded from the amnesty that Congress gave in 1872. So it would be a little hard to imagine that they thought they were going to give some future Jefferson Davis amnesty when they didn't want to give the actual Jefferson Davis amnesty. So that argument, I'm hoping, has been sort of either killed or mortally wounded by this Fourth Circuit opinion and won't really be an issue by the time we get to the Trump challenges. Another possible argument that could come up would be something like, well, does the criminal insurrection statute that I mentioned earlier, which has never been used, is that kind of the exclusive means by which you can enforce Section 3? Did Congress, in effect, preempt state law on the question of Section 3 eligibility or ineligibility through that statute? I think that's not the case. I mean, for one thing, it's a narrow provision of a criminal code, not some broad regulatory, part of some broad regulatory scheme that you might think creates an implied preemption. It's also a statute that's never been used, so it's a little hard to read it, something like that, so broadly as to preempt all of state law. And of course, you would also then be ousting the states from their role in regulating presidential electors, which we've been told many times, especially in the last election, is something that is generally a question for states to decide. The last thing, and probably the most significant argument that will come up when Trump is challenged is, well, there's one legal argument and one pragmatic argument. The legal argument is maybe Section 3 doesn't apply to him because it doesn't speak specifically about the presidency. No, it talks about officers of the United States and so on. And of course, the framers of the 14th Amendment were not thinking of an actual United States president or former president who was an insurrectionist at the time that the provision was ratified, right? They were only thinking about a Confederate president, but there was no specific example of a US president or former US president that they were barring. So there is room to argue that maybe they just left that out, you know, and therefore it doesn't apply to Trump. And you could reinforce that point by saying, well, people, broadly speaking, ought to have the right to vote for whomever they want. And so unless the text speaks clearly to the fact that the presidency is covered, maybe we should say it's not covered. I would describe that partly as a pragmatic argument because, of course, it's a pretty hard thing to say, if you're the Supreme Court, that Donald Trump may not run. He's barred from running, right? Even if the law seems to command that result. You know, there's a kind of irony in the way we think about Section 3, and I'll wrap up on this note. You know, if there was very little public support for someone because they were an insurrectionist, probably we wouldn't be particularly worried about barring them from the ballot. because we'd say, well, they have no chance of winning, so what's the harm in letting them run? If though they have a lot of public support, then it becomes very hard to say that they should not run. In other words, in effect, being a big insurrectionist can immunize you, because then courts might say, oh, well, you know, we ought to defer to the wishes of the people in wanting to vote for someone, or that would disrupt the electoral system too much for courts to bar a presidential candidate. You know, other countries, as Judge Kahn was pointed out earlier, have barred presidential candidates from the ballot under their own constitutional arrangements, but we've not done that. And one wonders whether the Supreme Court will want to take that on, even if the legal arguments for it are very compelling. But, you know, we have a long way to go in terms of the investigation of the January 6th committee, any possible criminal proceedings that may be brought, and so on, to see where the kind of zeitgeist is by the time these challenges are reached to court sometime in a year from now or a year and a half from now. Thanks.
Thank you very much, Professor Maglioka. So with such scant legal precedent illuminating this section of the Constitution, we will await word from the Supreme Court and look forward to seeing your continuing impact on this jurisprudence. Thank you. So our final presenter is Mr. Joseph Sellers. He is a partner at Cohen, Milstein, Sellers and Toll in Washington, D.C., and head of the firm's civil rights and employment law practice. Since joining that firm in 1997, Mr. Sellers has successfully handled numerous individual and class action claims to enforce civil rights, adapting legal theories to novel circumstances in order to recover for his clients. He frequently testifies before congressional committees on civil rights and employment law issues. Currently, he represents 11 members of Congress who are suing Donald Trump for civil damages for the injuries they sustained as a result of the mob attack on the Capitol on January 6th in Thompson versus Trump. He was lead counsel arguing successfully for all plaintiffs in that and 2 other civil cases brought against former President Trump and his associates, which were consolidated by Judge Amit Mehta for decision on motions to dismiss in the District of Columbia this winter. Mr. Sellers will discuss issues involved in his civil suit for conspiracy under the Ku Klux Klan Act of 1871, including Judge Mehta's decision. Mr. Sellers, the floor is yours.
Thank you very much, Judge Kahn. Thank you to the bar, and I applaud the bar for putting together such an interesting and important program. Let me begin by talking about the inception of this case and the fundamental legal basis, and then turn to the rulings by the court and try to present arguments from both sides here as to the arguments made in support of the motions to dismiss, our responses, and the rulings that ensued. So this case, as you know, the events occurred on January 6th and before. By January 8th or 9th, discussions had begun about whether to bring some kind of civil litigation, primarily between us and the NAACP, who are working with us on this case. They originally had discussions with Congressman Benny Thompson from Mississippi, who was very troubled by the events there and wondering what could be done to hold accountable the principal architects of the insurrection and seek some kind of redress for that. And in the course of investigating it, we came upon the statute that these cases primarily rely upon. It's found at 42 U.S.C. section 1985, subsection 1, a subsection that is rarely used. Many of us who practice in the civil rights area know section 1985, subsection 3, which is frequently invoked to challenge uses of power by governments or people acting in the cloak of power that claim to be abuses of civil rights and constitutional rights. This section, as far as we can tell, has been the subject of maybe 25 reported decisions since it was enacted as part of the Ku Klux Klan Act in 1871. So over 150 years, it's been been very rarely used. This suit was, as I said, originally contemplated very shortly after the insurrection, but there was grave concern that its filing not interfere with the impeachment proceedings that were already planned and being discussed. So it was developed and then held until the Tuesday after the first weekday after the Saturday when President Trump was acquitted by the Senate of the charge of impeachment. And so I think it was filed on February 17th. The complaint, obviously filed that early, relied on publicly available information that was then available. And so we've since learned many more things and are learning more things daily, but the complaint's merits and its susceptibility to being surviving a challenge were based on the well-pleaded allegations in the complaint. The case was originally brought, as I said, by Congressman Thompson. He eventually dismissed his claim when he was appointed by the Speaker to serve as chair of the January 6th Commission. But other members of who joined the case, including their fairly broad cross-section of the House Democratic Caucus, Karen Bass from California, Stephen Cohen from Tennessee, Veronica Escobar from Texas, Pramila Jayapal from Washington State, Henry Johnson from Georgia, Marcy Kaptur from Ohio, Barbara Lee from California, Jerry Nadler from New York, Maxine Waters from California, and Bonnie Watson Kohlmann from New Jersey. All of those individual members brought their case in their individual, not their legislative capacities, because they are seeking harm attributable to that was caused to them individually. They named, in this case, they named President Trump, Mr. Giuliani, the Proud Boys, and the Oath Seekers as four of the principal architects, they regard as the principal architects of the insurrection. The two other cases that Judge Kahn referred to that were also consolidated for purposes of the motion to dismiss were one brought by Congressman Swalwell of California that several weeks later, and one by two members of the Capitol Police Force, first by the name of Blasingame, obviously for injuries they sustained during the course of the insurrection. The plaintiffs are really seeking two things. One is accountability. They want to see that those that were involved are accountable, and they want to use the vehicle of the judicial system and its power of discovery that is not affected by changes in administration or anything else to get to the bottom of what's happened. And second, they do seek redress for harm that they suffered. The statute that they invoke primarily, as I said, is this one found in 1985, subsection 1. It prohibits conspiracies in which participants use, quote, force, intimidation, or threats to prevent any person or officers of the United States who hold any office, trust, or place of confidence under the United States from accepting, holding, or discharging the duties of their offices. So this is a help make sure the government, ensure the government continues to function type statute. And it is not a criminal statute, it's a civil statute. But as you can tell, the choice of when to initiate a claim like this doesn't require a prosecution memo or an approval by senior members of the Justice Department. But it is something that, therefore, as we've undertaken and is proceeding apace. It, as you probably can tell, also does not require any evidence or of dishonest means that may be required elsewhere. It has its own limitations, certainly, and the remedies may be included in that. The statute was originally designed to protect against marauders, especially members of the Ku Klux Klan and other kindred groups, from intimidating and harming members of the Southern congressional delegations who were returning to a unified Congress, and others who were governmental employees such as postmasters and revenue collectors, many of whom were African American, from rampant harassment. As Judge Kahn mentioned, this was the subject of a motions to dismiss. And in middle of February, Judge Maida issued a 112-page decision after 5 hours of argument, in which he largely denied the motion to dismiss as to Trump, as well as the Oath Keepers and the Proud Boys, and granted it as to Mr. Giuliani for reasons that I'll explain. So there are really 5 major arguments, categories of arguments that were raised, and I'd like to take them up. There are a slew of other minor arguments. Anyone who's interested in seeing a copy of the decision or any of the briefing, I'm happy to help provide you access to that. First, obviously, the question presented was, are members of Congress covered by this statute? So as I said before, it covers people who are officers, among others. And the argument that was made is members of Congress aren't officers. And they relied on a series of Supreme Court and other cases which interpreted the term officer as it appears in the Constitution, where it's been construed to mean persons who are appointed by the executive. And they relied very heavily on that as a basis to contend that Congress didn't mean to include members of Congress when it enacted a legislation to protect federal officials in their discharge of their duties. The response that the court gave and that we argued first is that back in the early 1900s, in 1919, there was a Supreme Court decision expressly rejecting the notion that the use of the terms made by the Constitution doesn't necessarily bind Congress in this use of the same terms. That Congress can reflect and use those terms for different purposes, and here it did. And in order to determine that, we examined dictionaries from the 1860s to get a better sense of what Congress had in mind with these terms, and we reviewed thousands of pages of legislative history that was, again, a precursor to this legislation, and it was extraordinarily troubling accounts of abuse that is today would unfortunately make us, even today with some of the events today, be outraged. And it's clear that the Congress from these statutes, from these dictionaries, intended to include members of Congress when it used the term officers and others who have special trust placed on them under the United States. Legislative history also makes reference to members of Congress and other legislators as having suffered from the harassment and abuse that the statute was intended to protect against. So the court ruled that members of Congress, as well as Capitol Police officers employed by Congress, are covered by this statute. The second issue, which has gotten probably the most attention, is whether President Trump is entitled to absolute immunity. There's a doctrine, a judicially created doctrine that many of us know, the doctrine of immunity, where people holding positions in the federal government, some may be entitled to something called qualified immunity, and those who exercise broad discretion, such as judges and certainly the president, are normally accorded what's called absolute immunity. Absolute immunity means that they are protected not just from liability, from being awarded damages against them, but from suit altogether. And the theory behind it is, if you occupy one of these positions, you should not be troubled and threatened and worry about litigation that might try to hold you accountable, even if later it's dismissed, because it could distract you from the duties that you otherwise have. In the 1982, in a case well known as Nixon against Fitzgerald, the Supreme Court ruled that the president has indeed absolute immunity. In that case, Mr. Fitzgerald alleged that he had been improperly discharged from a job by then President Nixon on grounds that he had been a whistleblower, and that the discharge therefore was unlawful. And the Supreme Court said that the president was entitled to immunity because the function he was performing, that of acting as a head of the personnel of the workforce, federal workforce, was one well within the scope of the president's duties, and therefore, whether it was unlawful or not, it was something that for which he should have immunity. So the court framed a language which we now rely on pretty heavily which is that the president is immune from suit for any conduct that occurred within the outer perimeter of the legitimate duties of the presidency. What the outer perimeter is been rarely tested, but it was the subject, the other end of the bookends of this, so the Supreme Court instruction in this area comes from another case, Clinton against Jones. This is a case decided in the late 1990s against Bill Clinton when he was president, but with regard to allegations of misconduct that occurred before he was president. And the court allowed the case to proceed, but in doing so made clear that the president can be sued with respect to actions, quote, unrelated to any official duties as president. Again, without being clear what those were, other than that their conduct that occurred before the president was president certainly qualified as duties that are unrelated to being president. The court also did something that's very important here, and that is it adopted what it would call a functional approach to determining what conduct qualifies for immunity. And it said that the immunities are grounded in the nature of the function performed, not the identity of the actor performing it. So the question is not whether the president was involved in these activities, but whether the president was engaged in duties that were functionally part of the official duties of the presidency. So the first argument that President Trump made, and by the way, if this had been granted, President Trump's claim against President Trump would have been dismissed immediately. The first argument that President Trump made was that he was simply taking care that the laws be faithfully executed, obviously language from the Article 1 of the Constitution, or Article 2. And the judge found that there was no role for the president in the tabulation of electoral college ballots. There was a role for the vice president, there was a role for members of Congress, there was no role for the president there. And the Electoral Count Act, enacted in 1887, that spells out in enormous detail the time of day when this is supposed to occur and who's supposed to be there and the like, that also, it makes no mention of any role for the president. So the court concluded that the so-called exercise of the duty to take care that the laws are faithfully executed does not extend to this area, because the president can't have any proper role over people whom he has no power. And he had no role here in which he could exercise that power. The second thing that the court addressed, as you might imagine, I'm going to come to this in more detail in a moment, is whether Trump's involvement in the January 6th events all of them were, as you might imagine, engaged in speech. He did not actually walk to the Capitol. He directed people to walk to the Capitol, and he exhorted them to come to Washington to begin with. All of that was speech, which is ordinarily accorded First Amendment protections. And so this is in connection just with whether there was immunity. And the court concluded, again, while speech is a critical function of the presidency, the key is whether his speech was made in the performance of official or unofficial duties. Did his remarks address matters within the scope of the presidency? The court, interestingly, rejected our argument that President Trump's remarks must be unofficial, as they were made promoting an insurrection against a co-equal branch of government, finding that that was too slender a reed in which to make such a distinction, even though it had some persuasive power. So the second argument we made, which the court ultimately adopted, was that the president was engaged in campaign activity and in terms of seeking re-election, and that was necessarily outside the official duties of the president. The court found that he was President Trump was in every respect seeking to secure his re-election, and made statements repeatedly to that effect. The court said, and I think a very important statement, the office of the president has no preference for who occupies it. Function of the presidency, therefore, is not to secure or perpetuate incumbency. And that is what the court found President Trump was trying to do. And so the court ultimately concluded that President Trump's activities that day constituted a form of campaign activity outside of the outer perimeter of the duties of the president. That issue, that ruling, is currently on appeal to the DC Circuit. There's an automatic right of appeal when immunity claims are denied. And so that is going to be argued sometime, I assume, this fall. The third defense was the First Amendment defense more broadly presented on behalf of all defendants. There's no dispute the court observed that Trump's conduct and that of others that was not associated with violence was predicated entirely on his speech, and the First Amendment grants very broad protections there. The court said only in the most extraordinary circumstances could a court not regard Trump's remarks as those protected by the First Amendment. But the court made a noteworthy statement. It said, this is a one-of-a-kind case in which the First Amendment does not shield the president from immunity. Relying on a series of Supreme Court decisions rejecting convictions for strong speech expressed to rallies supporting civil rights, the court charted a very distinct jurisprudential course. First, it said even vehement, caustic, and unpleasantly sharp remarks are normally protected under the First Amendment. But it said, relying on a Supreme Court case called the Brandenburg against Ohio from the late 1960s, that where that speech is associated with either imminent violence or either the risk or the actual imminent violence or lawlessness that occurred afterwards, that that speech loses its First Amendment protections. And so the court concluded that here, on the circumstances that were alleged in the complaint, this was more than just advocacy of the use of force or violence. This was actually a speech that was directed in inciting imminent lawlessness, lawless action, and it was likely to do so. And therefore, his remarks lost their First Amendment protections. It concluded that President Trump, the speech taken in the context of the campaign, fostered the impression of fraudulent, stolen election, was fiery rhetoric, and importantly, beside the president coming to urge the crowd to assemble and then dispatch the crowd in violation of a permit that they had to be able to assemble, what happened afterwards, when he saw the violence occurring and endorsed it and ratified it rather than trying to stop it, those were all key components of why President Trump lost his First Amendment protections. The court concluded that Mr. Giuliani never advocated imminent lawlessness, and therefore his claim against him was dismissed on that ground. Fourth, and I'm coming near to the end, is the question about whether the plaintiffs plausibly pled a conspiracy. The statute requires that the plaintiffs have engaged, that the defendants have engaged in a conspiracy. There was a common misunderstanding among the defendants that conspiracy required some kind of meeting in a smoke-filled room in which everybody mapped out a plan. That is not the current state of the law, at least in the civil context, of what qualifies as a conspiracy. The court laid out that it constitutes, conspiracy simply requires an agreement between two or more people to participate in an unlawful act or an lawful act that's taken unlawfully, and to take one or more steps in furtherance of it. That's it. The agreement can be express or implicit, so there's no need that there be some kind of formal agreement, and that the co-conspirators don't even necessarily need to know the identities of all the other co-conspirators. The Oath Keepers and the Proud Boys made very clear in social media that they were working together on and so therefore there was no question about them conspiring with each other. The Trump conspiracy was a little more important and noteworthy. Beside the phrase that President Trump used during the presidential debate, where he said to the Proud Boys, "Stand back and stand by," in which they followed by saying, "Standing by, sir," and then near January 6th, they announced over social media, "Standing by no longer." Those seem to suggest there was at least some level of meeting of the minds there. But the important thing here is that as to President Trump, the court observed, we plausibly alleged, conspired with the members of the crowd who were he exhorted to come to Washington. And then, as I said, he dispatched them to the Capitol in violation of their permit. and watched while they invaded the Capitol and engaged in violence, all of which constituted acts in furtherance of the conspiracy that were unlawful, and did so with those who were members of the crowd who also acted unlawfully. So the court concluded that there had been adequate pleading of the unlawful conspiracy. And finally, just very quickly, there was a final set of arguments about whether the acquittal somehow constituted a preclusive effect, that is, the Senate's acquittal precluded the litigation in this case. And the court said, of course, that preclusion requires, even if it were a trial in the Senate, requires findings that will establish what findings are preclusive in this case. There were no findings. There was no reasons given by many senators for voting to acquit. And ultimately, then Majority Leader, I think McConnell, concluded that they acquitted because the Senate lacked jurisdiction over President Trump, and that a dismissal for lack of jurisdiction has no preclusive effect. So with that, we are waiting for a chance to address the absolute immunity issue in the Court of Appeals. I'll just say one last point, which is about the question of what role can the private bar play in these kinds of things. And I would just say that one of the advantages of a case like this is that any of us who practice law can bring cases like this and can do so on our own schedule and without regard to any constraints politically or otherwise about how to do it. And I would be happy to confer with anybody who's interested in discussing a similar type matter. Thank you.
Thank you very much, Mr. Sellers, and for sharing your success in the civil litigation for January 6th damages, and for sharing your thoughts on how private lawyers can serve as a check on this kind of lawlessness by public officials going forward. So we do have a couple of questions, and I know we have to quit at 7:30, but let me just get to the first one from a member of the audience, and it is directed to Professor McQuaid, and it is in essence, what do you say to those who say, well, the country is very divided now, and there are those who say different events are viewed different ways, and former President Trump's call to Brad Raffensperger was just an inquiry, not really an effort to change the results, not an effort to seek a fraudulent result, and there's just too much being made of it.
Well, that's certainly a good point. And it's, I guess I would say this, that's why you have to investigate these things. There's a lot of frustration that the Justice Department has not yet filed charges. And, you point to all of these little facts that are out there. But what the Justice Department would do is not look at that call in isolation. There has been reporting that Mark Meadows met with Brad Raffensperger in addition to that call. What other calls took place? Trying to develop context for that call. And so rather than looking at it in isolation, what was the purpose of it? And then also, that's just, again, in Actus Reyes, you also have to look at, does it demonstrate a mens rea, a guilty mind? Is there an innocent explanation for it? And so those would also have to be probed. But of course, as we said, that one call does not the case make. We've also talked about the Actus Reyes could constitute pressuring Mike Pence. It could also constitute the efforts to pressure the Justice Department. So even if that one should not pan out, that does not mean the whole case falls apart. But no doubt, it's why the Justice Department is to investigate these things. Proving a case beyond a reasonable doubt is a very tall order. It should be. Our system is designed to allow 10 guilty to go free rather than one innocent being convicted. And so that is really just a lead that the Justice Department would want to investigate further.
Thank you. Professor Maglioka, some people say that the effect of 14.3 is anti-democratic and it would prevent voters from freely electing their preferred candidates. In Donald Trump's case, some folks say this is especially concerning given that his impeachment for his role in the insurrection did not result in conviction, and that he has not, at least yet, been charged with any crime at all for his role in seeking to overturn the results of the 2020 election. What is your response to that perspective on 14.3?
Well, first of all, any qualification for either serving in office or appearing on the ballot can be described as anti-democratic in that it limits some people from serving or running. So it's a bit of a circular argument. The question really is, does the qualification or disqualification apply to the particular person in question? Secondly, Section 3 of the 14th Amendment is on a different track from impeachment, right? It only reaches insurrection or rebellion. It does not reach any and all things that might be considered high crimes and misdemeanors for which impeachment can be applied. And thirdly, there is no requirement of a criminal conviction to trigger Section 3, in that all of the officials who were ousted during Reconstruction were people who had not committed a crime or been convicted of a crime. So none of those objections is sufficient. Now, to say simply, well, look, if we're in serious doubt about whether Section 3 should apply, does the fact that people, or a considerable number of people, want to vote for somebody, should that be a tiebreaker of some sort? Yeah, maybe. Okay, but I mean, it cannot be allowed to simply control the outcome.
Thank you. Mr. Sellers, could you just tell us why you thought the KKK laws were more effective as a vehicle than the tort laws in assuring accountability in a case like the one you brought? Some of the other cases involved tort claims.
Right. You're absolutely right. There were some of the other cases brought common law tort claims. We thought it was more important, and this statute, by the way, sounds in tort. So this is a tort type claim. We thought it was important to present a very streamlined, highly focused cause of action, to focus attention on this, as I said, really being about the effective management and discharge of duties of the government. And our clients, who are members of Congress, thought that was a very important message to be sent. And they were very strongly in support of filing a very streamlined complaint that focused only on this one cause of action.
Okay, thank you very much. I know that we're supposed to close out in a couple of minutes. I want to thank our presenters, Barbara McQuaid, Gerard Maglioka, and Joseph Sellers, for, I think, their incredibly stimulating presentations and so timely. And I want to thank also you, the audience, for joining us today. We hope you found the program enlightening and illuminating and perhaps inspiring. But before we let you go, I would like to turn the microphone over again to Task Force Chair Stephen Kass for a brief but important announcement. Steve?
Thank you, Marcy, and thank you for doing such a characteristically wonderful job as moderator. I did want to mention to our audience that we have another program coming up a week from tomorrow, on Thursday, June 2nd, where we will be looking at the question of whether law firms, US law firms, should continue to practice in Russia, China, and other authoritarian regimes, and if what are the conditions under which firms should responsibly withdraw from continuing to operate in such countries. So we look forward to your joining us on Zoom next Thursday at 7 o'clock, not 6, but 7. And we will have 3 very important speakers to address that question. And we look forward to seeing you then.
Thank you again.
With that in mind, Marcy, unless you have further questions, I think we are adjourned.
Very good. Thank you. And thanks to the speakers once again. Take care.
Thank you all.